In our first edition of our last video, we laid bare, corrected the notion that people have about next of kin. Made us understand that next of kin does not automatically give the person such right to inherit the estate of a deceased. That a next of kin is just like a contact person in case of emergency or in case of some decisions making where the descendant or where the person who made him the next of kin is not available. Today in this our video, which is the part 2 of our video, what we are going to discuss are those who are the people that are qualified to inherit the estate of a deceased person. Hello viewers, I am Charles Uzoka from Efuna, still the head legal amateur properties. I'm here to educate us on those who are qualified to inherit the estate of a deceased. Those who are qualified, this is a question of law, which can be either English law, customary law, Islamic law, or the law of estate of administration of estate of that particular jurisdiction. If we talk about this, the law of succession of estate of a deceased person, the most is being guided by two notions, either the notion of testacy and intestacy. When you say testacy means when a person dies and he has a valid will, left a valid will before his death. While intestacy is when a person has died without a valid will in place. Now we talk about testacy. When a person dies testate, it means he has a valid will. And whatever provisions in that will, those people who he mentioned specifically as beneficiaries in the will, they are the people who are being recognized. A next of kin cannot come in because he is not recognized. The only way next of kin can come in is only when he is also apart from the part of the people that were mentioned in that particular will. So when a person dies testate has a will, whatever provision has to be respected by that person, by people who are alive and who are around. Then when you talk about the issue of a person dying intestate, that's without a valid will. In such situations, the law that guides it either the type of marriage consummated by the deceased while he was alive, or the type of the law that he practiced while he was also living. For instance, when the person dies in intestate, what the law recognizes in law of succession is the first people that the law recognizes are the widow, which is the wife or the spouse of the deceased person and his immediate children. Then after that also the children, the children also, that those that they be, though nobody is being referred, that you cannot refer to anybody as illegitimate, but those children that were also born outside wedlock, they are also recognized in as much as the deceased, when he was alive, he recognized them as their children. Those are also those that have been recognized, first people to recognize in succession. The second set of persons to be recognized are the parents of the deceased person. After the parents of the deceased person, we also talk about the half brothers and sisters of the deceased person. After the half brothers and sisters, you also have the grandparents of the deceased persons. After the grandparents, then comes the uncles. Then after the uncles and aunties, then after the uncles and aunties also, you have other relations. That is what the law recognizes in the order of succession to inherit an estate of a deceased person. You cannot go outside these laws, what the law has prescribed in order to inherit the estate of the deceased person. You can see also section 42 of the sub 2 of 1999 Constitution as amended also prohibits indiscrimination of laws of inheritance, either because of circumstances of marriage, religion, or by gender. Like in section 42 sub 2, it condemns where you discriminate a female child from inheriting property or estate belonging to a deceased person because she's a woman or because of religion, the law abhors that. Any law which is customary that is contrary to natural justice, equity, and good conscience, the law does not allow that. What we're saying in essence is this: when a person dies intestate, the succession of estate will be determined by the circumstances, determined by circumstances of marriage or by the law which he recognized while he was alive. If the marriage, his marriage was contracted under the Marriage Act, customary law does not suffice, cannot be applied. Customary law cannot be applied if the person practiced the law, maybe the law he practiced was customary while he was alive. That's the only time you can apply the customary law. So where he contracted a marriage under the Act, the law that will apply is either the English law or the laws of estate administration of that particular jurisdiction. Customary does not suffice. So viewers, what I've tried to make us understand is that for when a person dies testate with a will, a next of kin can only inherit or be recognized as somebody that will a successor in the estate of the deceased person if he was strictly or it's absolutely named specifically in a particular instrument or document of the that the deceased person made before he died. If minus that, a next of kin cannot and can never inherit the estate of a deceased person on account of the fact that he was being appointed as a next of kin while the deceased was alive. Also, in the case of intestacy, a next of kin can also, because the deceased does not have a will and he is dead, so because he's being appointed as a next of kin, automatically he becomes a beneficiary of the deceased estate. No. The only function of a next of kin in such situation is that he can be called upon for advice, for suggestions in case of any emergency or in case of any issues that arises, or where in this type of condition where he died, the deceased died intestate. He can be given the saddled with the responsibility of gathering the members of the family together to decide on how to go about to getting a probate, that is, get the letter certification for the administration of the deceased estate. Viewers, we've come to the conclusion of this ambiguity surrounding the issue of next of kin. I don't know how I've convinced you. I don't know how I've pricked your conscience, but I don't know for any further tips or any further inquiries or any further education you need on this, please, you can contact us at Amucham Properties. Contact us on all our social media handles.